Well, good afternoon, everyone. Thank you for joining us today. In case we haven't met, I'm Gail Lynch, and I'm president of the Connecticut Valley LERA. You may have just heard me speaking with Emily Smith, who is from our national LERA organization, who has been helping us over the past year getting our website set up and with many different things that we've been working on. And she has graciously helped us with our hosting this via Zoom today. So thank you, Emily, and to Bernadette as well. So I want to give you a couple of quick updates before we start our program. First of all, many thanks to all of you who responded to our survey monkey that we distributed about a month ago. Our steering committee was delighted to receive the positive feedback about our programming. And what you shared was that once we can start meeting in person again, that people would like to have some sort of mix of meeting in person sometimes, but then continuing, perhaps doing virtual sessions as well. And we're going to take that into account, as well as some of the program ideas that we received. So please stay tuned for that. Second, I am thrilled and humbled to announce that our LERA chapter received a merit award from the national organization in 4 categories: outstanding programming, consistent chapter excellence, membership growth, and or development, and consistent meetings. So getting this kind of recognition during perhaps one of the most difficult years in our lifetimes is a true testament to the work of our steering committee and to your continued support. So thank you for helping us earn that achievement. And several of us who serve on the steering committee will accept the award at our virtual LERA annual meeting in June. And finally, our last program of this programming year will take place on June 4th. We will have management and labor perspectives on whether employers should mandate the COVID vaccine. They'll discuss issues around privacy concerns, the legality of incentives, and also things about, sending kids back to schools, and what about those parents who may continue to want an exemption for their students and so forth. So, and how does that perhaps then implicate who comes back to work? So lots to discuss there. It should be a great presentation. And so now, just in terms of some housekeeping details, everyone is muted to preserve sound quality. Our program will run about 45 minutes, but the presenters would love to hear your questions during the program. So please put them in the chat, and I will continue to monitor. And we could either unmute you, you could ask your question, or I could ask it for you. And then we can still have time for some Q&A at the end. The presentation is being recorded and will be accessible from the LERA website. So if you have colleagues who are unable to attend today, they will be able to watch this at their leisure. And then everyone who is present will receive a CLE certificate. And also the presentation slides will be made available. So that's it for housekeeping. And now I would like to turn it over to our presenters, Gabe Jiran and Eric Chester.
Okay, hopefully everybody can see that. So for those of you who don't know me, I'm Gabe Jiran from Shipman and Goodwin. I primarily represent management, and with me is Eric Chester, who is primarily on the labor side. So when we were asked to talk about employee free speech in the workplace, Eric and I talked about it, and we can go through some of the background on what the legal standards and all, but really we came up with a bunch of scenarios, and we're going to go through those and kind of give you examples of what is either on the protected side of free speech or the unprotected, or maybe some gray area in the middle. And I think it'd be interesting having somebody from labor and somebody from management to give perspectives on that. I know that when we were preparing for this, a lot of times we agreed, although we may not admit that in other venues, but a lot of these examples seem to be obvious at first, but then there are some wrinkles in it. And so hopefully by going through those, we'll give you a sense of kind of things that you need to think about, whatever side you're on, or if you're on neither side and in neutral, the types of things that are important to consider. And so I'm going to kick it off just with the first legal standard involved. So for the public sector, of course, the First Amendment, that's no surprise, is applicable. And we all know that the First Amendment is very broad. It's of course not unlimited. And in the employment context, there's a balancing test. Many of you have probably dealt with this balancing test, the Pickering balancing test, where the speech, in order to be protected, has to be on a matter of public concern first, but then it can't have a negative impact on the work environment or work relationships. This is a very broad statement of what the First Amendment analysis is, but it recognizes that we want employees to be able to speak out on important public interest types things, but there's a balance if they're doing so in their employment context or in a way that affects their employment relationship, that we have to balance the importance of that First Amendment right versus how is it affecting the employee in the workplace. And you'll see some of these examples that we're giving are public sector related, others are private sector, but walking through the scenarios, I think you get a better appreciation as to how that balancing goes on. And so I'm going to turn over to Eric to talk about the private sector.
Sure. Thank you, Gabe. And thank you for having us. Just by way of introduction, briefly, I'm Eric Chester. I'm with Ferguson, Doyle, and Chester. And as Gabe has correctly pointed out, we represent primarily labor unions, most of which are in the public sector, but we do also represent a number of workers in the private sector, primarily in healthcare. Just to pick up a little bit on what Gabe said regarding public sector, and most of my remarks are geared obviously towards labor advocates who are attending, but kind of the default rule that I like to relay to union leaders so that they can educate their members on what type of speech is protected and what type of speech is not is you ask yourself, is the person speaking as a citizen where the speech would be protected by the First Amendment, or is the person speaking as an employee? And if it's the latter, if they're speaking as an employee, the speech is not going to be protected by the First Amendment because that speech is made in the course of their official duties. And to Gabe's point earlier, even if they are speaking as a citizen, there's still that balancing test. Is the speech disruptive to the work environment? Does it interfere with the working relationship, not only with the employee and the employer, but the employee and his or her colleagues? As far as the private sector goes, there are protections and there are limitations as to what employers can do in limiting First Amendment speech. And the statute cited in the slide, that's Connecticut's what was referred to as the Whistleblower Statute. This protects employees from discipline or discharge for exercising their constitutional First Amendment rights. And again, the statute's very clear in the cases defining and clarifying the statute are clear in that it applies to private sector employers as well. And there, if a private sector employee is exercising his or her First Amendment rights, they should not be subject to discipline or discharge for doing that. However, the speech cannot, just like Gabe said earlier, in the public sector, cannot substantially or materially interfere with the employee's bona fide job performance. So in essence, if the employee is speaking in the course of her employment, more likely than not, it's going to be viewed as interfering with the employee's job performance and not be protected First Amendment speech. And again, the speech can't be so disruptive that it interferes with the working relationship between both the employee and the employer, and I would submit, employee and fellow employees. And just by way of background for the statute, we see this statute being used pretty regularly in that, it does call for punitive damages in the event that a private sector or public sector employee is discharged for exercising a First Amendment right. So there's punitive damages, there's the opportunity to collect attorney's fees. And interestingly, within this statute, there's also the opportunity for the employer or the defendant to seek attorney's fees if the claim is brought unreasonably or without merit.
one of the only statutes out there, I think, that allows for that.
Yeah.
Yeah. Well, let's talk about some of the factors that are involved in determining whether it's protected. So this, under both the Connecticut statute as well as the U.S. Constitution, these factors apply to determine, in that weighing of the interests, whether the speech is protected. So, the need for harmony in the workplace is very kind of general and amorphous, but if you go down a little bit further and dig into it, you look at things like, is there a close working relationship between the speaker and any of the persons who would be affected by the speech? Coworkers, for example. That interpersonal relationship between employees can be very important. And sometimes employees who are saying things can offend their coworkers to the point that it really damages the working environment to the detriment of everybody involved. And so that's really a key factor there. And then when we look at the next few bullets there, the time, manner, and place of speech, the context, those are, for those of you who are lawyers out there, you'll remember that from your constitutional law class. Time, manner, and place is a big thing in the First Amendment analysis. In the workplace, what we're seeing is that this may come into play where people are engaging in speech outside the workplace, but then it finds its way into the workplace. Social media being the greatest example of that, which is very common. And so we're going to talk through some scenarios on that, but also the degree of public interest in the speech. So the old rule is personal complaints are not protected because there's not public interest in that. So for example, if there's an employee who gets into an argument with his or her supervisor over their evaluation because the employee doesn't agree, and then the supervisor doesn't agree with the employee who's disagreeing with the evaluation. Yeah, that's a personal issue. Not very frequently is that going to bring out something that's a matter of public interest, but there's a whole lot of other things that can come up in the workplace that are in the public interest. And so that's a key factor here. How much interest is there in the public? Things like politics, race relations these days are very, very hot topics. And there's obviously a lot of public interest. So those ones are easy. But when you get into things that are not so obvious, that's where the real analysis needs to take place as to whether the employee is talking about something that would fall under the cloak of the First Amendment or the Connecticut statute because of the public interest. And then finally, this goes back to the harmony in the workplace idea, is whether the speech impedes the ability of other employees to perform their duties. So this is the kind of the typical disruptive employee who's saying or doing things that is causing a problem within the workforce. Employers have the latitude to address that, but they have to be careful on the other side too, to make sure that they're not trampling on somebody's First Amendment rights. So that, oftentimes we'll get calls where we have to walk this through and say, what exactly were they saying and how were they saying it? And sometimes it's kind of dicey as to how you address it, or if you can address it. And so I guess the rule there, or the guidance is kind of proceed with caution, unless it's something very obvious is going to be protected activity. But even then, where it's obviously protected activity, if it's being disruptive to the workplace, you need to figure out how much can you control. Is there a time or a place that is better for these discussions to occur in the break room or whatever? Is there ways that you can handle the issue with between employees? So you make sure that you're recognizing whatever protections may be there, but also recognizing the right to, make sure that every employee has the ability to come to work and feel comfortable in doing so.
If you could just, Gabe, if you could stay on this slide for a moment.
Sure.
If I could just piggyback on some of what you said. Unions are seeing a lot of this as well. And I think, as we all know, and we've all have seen, that the country has become so divided, and the discourse has become so divisive that people are being offended more often than they were perhaps 4.5 years ago. So when an employee parks, his or her car, in the employee parking lot filled with bumper stickers that are on one side of the political spectrum, and more often than not on the fringe of that side of the political spectrum, it can be offensive to those who are on the other side. And, and as I think we can all agree, more and more often than not, people are on one side or the other and wind up being offended by the opposing side. So we're seeing that a lot as well. I mean, union leaders have fielded complaints that I shouldn't have to come to work and see my coworker with this bumper sticker on his car that's offensive to me, or the screen saver that he or she may have on their computer, or even something that they may be hanging up in their respective individual workplace, so that people are asserting that they're offended by that. And employers are in a tough spot where they're going to have to decide what is speech, whether or not the speech is a matter of public concern, whether or not it's protected, and then even if those things are all true, whether or not it's disruptive to the workplace. Okay, the first scenario, an employee, I'm sorry, this isn't the first scenario, I apologize. So the right to free speech, an employee may be disciplined or discharged even if he or she has engaged in protected speech if the speech substantially interferes with the employee's bona fide job performance or the work relationship. I was just alluding to that in the previous slide. So again, it is a matter of public concern. An employee is making speech or presenting speech that he or she thinks that the last presidential election was somehow corrupt, quote unquote stolen, and does that speech interfere with not just that employee's job performance, but as Gabe said earlier, their coworkers' job performance? Is it making the coworkers uncomfortable? Is it interfering with the workplace? And I would say on that, from a labor side, is that the employer ideally will have a policy on speech, what type of speech, what type of behavior is acceptable in the workplace, and that it'll be uniformly applied, uniformly enforced, irrespective of what side of the political spectrum the speech may land on. So the last thing you want to see happen is an employer potentially disciplining speech that substantially interferes with the workplace because it doesn't align with management's political ideology. That would not be, obviously not acceptable and be ill-advised. And I would say same thing for unions. The last thing a union was going to want to do is pick and choose which members it's going to defend based on what side of the political spectrum the speech lands on. I think this comes up late in the slides, but unions will need to be uniform in their representation of members, just like employers will need to be uniform in their application of policy, irrespective of where that speech finds itself on the political spectrum.
And I think that's a real challenge for both sides, in not just on politics, but on other social issues, things that are clearly matters of public concern, they're a matter of public debate or discussion. Both sides, in particular our employers, since they're the ones that, could potentially be disciplining somebody, you can't let their own beliefs creep into that discussion. And that's one of those moments where I think employers, before they go down a disciplinary route, have to take a step back and say, well, wait a minute, is this protected? Even though I don't agree with it, is it protected or not? I think that what I've seen with clients is that the higher up you get in the organization, the easier it is for that discussion. It's really kind of the frontline managers that are a big concern, because they're the ones dealing with issues right there on the spot and maybe not taking the time to think it through and talk to others about how do we approach this. And so I think, as you go back to your own place of work, wherever side you're on, I think that's something you have to consider about, this is really one of those times where you want to take a time out and say, how are we going to address this issue from one perspective or another? Because we don't want emotion to drive decisions. We want it to be based on, a good analysis and fairness, so that it doesn't look like we're singling out one side or the other. It's challenging, not easy for sure. So we do have our first scenario next. So here you have an employee who's posting on Facebook that his wife was not hired by the town because of gender discrimination. So this is obviously a public sector issue. And a few years later, he claimed that the Board of Fire Commissioners has held an illegal meeting under the Freedom of Information Act. So I guess if we look at those two together, is it free speech in either case? If we go through the analysis, at the outset I said personal gripes are not really protected if it's just personal to the employee. And if that first bullet might cause you to say, oh, he's just upset because his wife wasn't hired. But I think the key there is that now he's saying it was because of gender discrimination. And there's no doubt that gender discrimination is a matter of public concern. So I think it's going to fall within that protection. The same is true about alleging an illegal meeting under the Freedom of Information Act. Whatever the motivation may be of this employee, that's really not important here. If the employee's saying, I think the town violated the law, as long as it's true, there's a reasonable basis for doing so, that's protected activity. And in fact, the employee's probably also, for sure, protected against retaliation on the gender discrimination and on the FOI. There may be other statutes that apply within Connecticut to say, you can't retaliate against somebody for pointing out violations of the law. And so I think this is a pretty easy one. I don't know, Eric, if you would disagree.
No, this would be, I think, straightforward if we don't see what the employee was doing here for work, but regardless, the employee works for the town, regardless of what department his wife or his spouse was applying to, pointing out the fact that the town may have engaged in gender discrimination is a matter of public concern. It would be hard pressed to suggest that him making that post somehow substantially interfered with the workplace. And it's not really related to his specific job duties. So he's speaking as a citizen. Yes, it may be viewed as a personal gripe, but nevertheless, he's speaking as a citizen, pointing out a violation of the law. And same thing for the second one. A commission is holding an illegal meeting, pointing out that violation is protected speech.
I mean, I can argue a lot of things, but it's going to be hard to argue that pointing out illegal activity is too disruptive to the workplace that it's not protected. I think that's a loser. Let's go on to the next one.
Okay, a juvenile drug counselor has a personal blog, and within that, he or she is supporting the legalization of marijuana. This one's not as straightforward. I think, given the recent developments in the law, perhaps it wouldn't be considered as problematic as the trend is towards legalization of marijuana. But putting that aside for the moment, assuming that the use of marijuana is illegal, especially for juveniles, would this speech be considered protected by the First Amendment? Is it a matter of public concern? I think that first piece of the analysis is yes, it is. The legalization of marijuana is in the news. It's a political issue. It's an issue before our legislature. It's a matter of public concern. Is it disruptive to, well, one, is it related to his job duties? Clearly it is. Clearly it is. And one could argue that he is speaking about matters of his that are related to his job duties, not necessarily as a citizen, and therefore it may not be protected. And then lastly, even if it is protected, is it disruptive to the work environment, to the workplace? Is it going to undermine what he's trying to do as a juvenile drug counselor when he's publicly advocating for the legalization of a controlled substance? So, I mean, as much as I wouldn't want to say that this person's in trouble, I think this speech would be hard pressed to argue that it's protected and therefore insulated from any discipline by the employer.
Yeah, and I agree. I think the key is the employee's a juvenile drug counselor. If this were, if we changed the scenario and said it's a custodian that works in a factory and supports the legalization of marijuana, that's a much tougher situation. I don't know, because there's no tie to the employee's job duties. It's not inconsistent with what the employee does. I think that's a totally different scenario. And so this kind of drives home the point. You have to look at these factors in determining whether it's disruptive or inconsistent with what the employee does. So here's another one. A fire lieutenant, who's also the union president, is expressing opposition to the hiring of a new fire chief, and then is later demoted. So, all right, there's a lot of things going on in this one. First of all, you have the position of fire lieutenant, talking about the next chief. You have also union president. So you have to think about, well, is this person speaking as a fire lieutenant, as the union president, or both? And then what is he talking about? Is it a matter of public concern? Well, yeah, I think the hiring of a new fire chief very well could fall into that category. What we don't know by this scenario, and that's purposely so, is what exactly is the employee saying? You know, is this something about where statements about, well, this person's not qualified, or there's some issues in the background or something like that, that would be, you know, of interest to the public, that they want a qualified individual to be the next chief? Or is it something, well, where the employee's saying, well, you know, he was my supervisor and he gave me an unfair evaluation? I think that matters. That context does matter, and that was one of the factors that we looked at initially. But let's just say this is, you know, he's talking about the qualifications of the next fire chief, and what the town really needs is somebody that has been a chief or deputy chief in a very large municipality in order to serve, you know, the population. And so therefore, you know, that's legitimate. And the employee opposes this new chief. Is that going to be now too disruptive to the workplace because the employee is speaking out about a new chief? I think it's a bit of a tough one. Again, it's the way it's presented, what exactly is said, and what the issues are that are raised. But I gotta say that for the most part, I would be leaning to say this is protected, as long as it's, you know, again, just focused on things that would be in the public concern. And I don't think that the employer would be able to say, well, just because you didn't want this chief, that therefore that was inappropriate and it's not protected. But, you know, there's a lot of factors that matter there. I think when you layer on the union president, that gives it even a heightened level of potential protection, because it's a dual role there. As we know, speaking out in a capacity as a labor representative has its own set of protections. And so, you know, based on just a very general set of facts here, I think that this is probably going to fall within the realm of protected speech in most categories, unless it's really just a personal thing between he and the future chief.
So if I may, Gabe, I had this case. This was one that I kind of pulled out of the Rolodex, and here the fact that, and it's not laid out in the slide necessarily, but the person speaking was speaking in his capacity as the union president. And like Gabe said, that is more often than not going to be considered, you know, protected, concerted activity. And what I will often advise labor advocates to do is to do just that. If, again, putting politics aside, because that can often put union leadership in a place it doesn't want to be in. But here, the membership, the overwhelming majority of the membership felt the chief was not qualified. They wanted somebody that was going to be promoted from within. They didn't want someone coming in from the outside. And they made their voices heard, but they did it in the context of union speech, which is protected. And here, you know, this happened, and the union president ultimately wound up being promoted back to his position. But I think for those of us on the labor side, if you want to make speech and you're not sure whether or not it could be protected, one way to ensure that it will be protected is to have the speech made through and by union leadership. As like Gabe said, that does add an extra layer of protection under whether it's LERA or the State Employee Relations Act or the Teacher Negotiation Act. Those would often be protected.
All right, let's go on to the next one. I think this one's on you, Eric.
Right. Okay, we've seen this happening both in first responder employment settings as well as healthcare, obviously. So a firefighter or healthcare worker complains about a defective policy relating to COVID, claiming that the policy puts whether it's EMS workers, healthcare workers, and the public at risk. Now, going through the analysis, is this person speaking about a matter of public concern? I would say yes. Now, if they're speaking about this respective employer's COVID policy, perhaps not. But speaking about COVID, the pandemic was clearly a matter of public concern. One could certainly make the argument that this person, this employee, healthcare worker, first responder, is speaking about a matter of public concern, especially if they're claiming that not only does the policy that they're claiming is defective put their employees at risk, but it puts the public at risk. And when you make that claim that, hey, listen, our COVID policy at this hospital, at this fire department, at this police department is putting the public at risk, well, then clearly you're speaking about a matter of public concern and you've passed kind of that first hurdle in the analysis. The second one, not so easy. You're speaking about your employer's COVID mitigation policies. Are you speaking as a citizen? Or are you speaking as an employee? Are you speaking about matters related to your job duties? And there, you may not be able to overcome that hurdle. But again, perhaps to the extent that you're saying that your employer's policy is putting the public at risk, perhaps you get over that hurdle. I would advise against doing this, and perhaps doing it through the union if you're going to do it. But to have a nurse, to have a police officer, a firefighter come out and say, my employer's COVID policy is defective, it doesn't keep us safe, and it doesn't keep you safe, arguably you're speaking as an employee. And there the speech may not be protected. You're not speaking as a citizen. And that this employee could be at risk for discipline.
Yeah, I would agree with that. And, using firefighter or some other public safety makes it a little bit more difficult because they serve the public. But I think it's a point well taken for outside of the public safety realm where you have another type of employee talking about the COVID policy for that specific employer, whether that would fall into it, I think is, it lends itself that this is somebody speaking specifically about their employer and its policy, which makes it not a matter of public interest. But I think with COVID, I'm more likely than not going to say it's, it's in the public interest, and it's just a matter of exactly what the speech is as to whether it's protected or not. So we talked a little bit about political speech already, and so I'm not going to spend a lot of time on this because we do have a couple scenarios on this. But political speech is protected speech, of course, under the First Amendment and the Connecticut statute. And so it's the same general rules. Employees have a right to engage in political activity, but not all activity, of course, is protected. And same thing about the impact on the working relationship. And I think that, what Eric was talking about previously with the bumper stickers and that, what I've seen is that the bumper sticker doesn't cause a problem. It's the discussion about the bumper sticker that causes the problem. And then it's this, political debate that occurs in the coffee room or at the water cooler or wherever else. And then it develops into something else. And so, time, place, manner, the context, all of that becomes important in this analysis. I think the scenario that Eric's going to talk about here is a good example of this.
Okay, so here we have a clerk, public sector, posting conspiracy theories about the stealing of the 2020 election. Clerk's told by her supervisor, take the post down or else. Is this something that the employer can direct the clerk to do? I guess one thing, you go through the analysis, the election clearly is a matter of public concern. Now, is this person speaking as an employee? Is the person speaking as a citizen? I think it, more often than not in this case, you'd be able to make the claim that the person is speaking as a citizen. So therefore, it could be protected. Then you get into whether or not it's disruptive to the workplace, whether or not it has a substantial impact on either her ability to do her job or her coworkers' ability to do their job. Is it disruptive to the work? And it could be. Given how many people see this post, I mean, if it's a Facebook post and if it's her own personal Facebook page and it's not viewed by all of her coworkers, I think perhaps the employer would be hard pressed to say that her Facebook post is disruptive to the workplace. And I think the employer would have to show that. If her position is she's some type of clerk that maybe oversees elections, then it may be disruptive. It may undermine the ability of the office to do its work. In other words, it calls into question the legitimacy of the 2020 election. It may call into question the legitimacy of what the clerk is doing if she's involved in anything having to do with elections or that type of thing. If the clerk says, I'm not taking it down, it's my Facebook page, it's my right, it's my First Amendment right to make this speech, and she's disciplined for it, I think she may have a viable claim under the state statute and under common law as well that her First Amendment rights have been violated. Unless, of course, the employer is able to assert that it was disruptive to the workplace.
Yeah, I think Eric hit on a good point there. It was who could see it. So it's particularly with social media. I've had this situation come up where somebody was an employee posting on a public site, so anybody could go and see it. That's much different than somebody's posting this on a private site where only individuals who have asked for permission to see the content can see it. That goes to the disruption aspect of it, because it can have a dramatically different effect depending on who can see it and how many people can see it. And so that's another thing to consider. You've probably seen this where somebody sees something on Facebook, they're friends with the person, and then they start disseminating it around or forwarding it, and then it kind of grows from there. That's much different where there's a small group of people on a private site that are looking at something, and you can't, an employer would have a hard time saying, well, it's disruptive to the workplace when only 5 people saw it and they were all friends of this person. So that's a factor. Content-wise, there's going to be some posts that are just obvious. Here's one, it's a real post that was, I don't know if it was on Twitter or someplace else, but in this particular one, the employee was criticizing the Black Lives Matter movement, calling protesters animals and savages, suggesting motorists should drive through the protesters. This picture here was really on somebody's website or social media. Now here, obviously it's political speech, so we're just going to assume that it's in the public interest. But this is where it crosses the line, I think, clearly, and I think few people would argue with this. You're advocating violence against people who themselves are asserting their First Amendment rights. I think that takes it out of the realm of protection. I think it clearly can be disruptive to the workplace and is a real issue. I've seen a number of these cases, not this exact post, but in particular with not just this topic, but a lot of other things that have been the subject of protests lately, folks weighing in on it and then doing so in a public manner. And employers have been dealing with it in various ways, depending on the severity. But I think this is clearly one of those things where if other employees are seeing this, it's almost de facto going to be disruptive to the workplace. But I think that the employer is still going to have to say that there were enough people that saw this that we can't have this, and the employee can be told to take it down, or I think even discipline for it, because it's just, I don't think it's going to be protected speech.
Hey, Gabe and Eric, we actually have a question that came in related to the Black Lives Matter movement. And that is, how should an employer deal with regulation of masks with slogans on them? And I would imagine most workplaces are requiring their employees to wear masks. And then the question goes on to ask, what about masks that say Black Lives Matter or Blue Lives Matter that are worn in the workplace? Do you want to comment on that?
I've had that come up, so I'll try it first. first of all, if an employer is going to say you can't wear that message on your mask, they better have a content neutral policy that says that you can't wear pins or hats or whatever with slogans. And as long as it's content neutral and it has a legitimate business reason, for example, for uniformity of appearance, like for most commonly, like in a hospital setting, we want everybody who's a nurse to wear a blue scrubs, blue mask, blue hat, the whole thing. You can't have any slogans other than the hospital slogans. I think that that's fine. If the employer's not doing that and they're allowing people to wear Red Sox masks or Yankee masks or whatever else, then I think it's a much more difficult thing, because then it's regulation of somebody's beliefs. And I think that the employer is going to have to show that there's actual disruption. Now, there may be scenarios that that's true, but it's going to be the context, who else can see it, and what is the effect that's going to be the issue. It's very similar to somebody having the bumper sticker for a presidential candidate. Is that alone disruptive? Just because people don't agree, I don't know that it is, but it might be the conversation that occurs after that, or the nature of the political slogan, or in this case, the speech on the mask that could be a problem.
Yeah, I would agree with Gabe. I think it's in the employer's interest and the employee's interest that there be a content neutral, uniformly enforced policy on this. And I think it would be certainly a policy that would be enforceable. And I would recommend it, quite frankly. And I think, one thing an employer would want to, I said this earlier, would want to steer away from is being selective in what side of the political spectrum it's going to support or not support. And we'll go to education for the moment. And this particular post that you're seeing on this slide was, again, this was one that came our way. And this was a teacher in an urban district teaching primarily students of color. And the employer had a big problem with it, understandably so. However, the union obviously is going to represent this person as vigorously as they can through a disciplinary process, regardless of where this person falls on the political spectrum. What you don't want to have happen is let's say, for example, in an urban school district where the administration may be supportive of the Black Lives Matter movement, endorsing employees wearing masks that may say BLM on them, but punishing employees that wear masks that say something else, to Gabe's point earlier. That would be a mistake, just like it would be a mistake for the union to decide it's going to vigorously defend these members over others. So I think a policy that's content neutral is good for the employer. It avoids litigation, and it's good for the employees, because not only is it neutral, but it'll avoid the disruption in the workplace when people are wearing masks with different political slogans, and you find you have two different workforces, one on one side of this political spectrum, one on the other. That's not good for anybody.
All right, Eric, I think this is you too.
Yes. Okay, so obviously speech that is discriminatory, speech that is harassing, speech that is threatening, that's not protected by the First Amendment. The First Amendment doesn't protect that speech, so you don't even have to go through the analysis. Somebody constantly sending somebody chats, posts, correspondence through social media that the person is not responding, that obviously is harassing. It would not be protected by the First Amendment. Liking, commenting favorably on posts is a problem for a number of reasons, but primarily, and I'm not a Facebook expert, but I do see them come my way a lot, is that these reposting things, it appears on your page. So it's as if it's your post. You're endorsing the speech. So if you have harassing, threatening, discriminatory posts that you've liked or that you've reposted, it's not going to be a very viable defense to say, it wasn't my post, I just reposted it. That's not a defense that's going to get you very far. Again, having the post appear on your Twitter feed, on your Facebook page, even if it's a repost, is, in my view, And I think I'd be interested to hear from an arbitrator, but I would suspect from an adjudicator, they would view it the same way, that this person posted it on their page, whether it was an original thought or reposting from someone else. Same thing for the pictures. Pictures that are harassing, pictures that are could be viewed as threatening, or pictures that are obscene are not protected by the First Amendment. You're not speaking about a matter of public concern. It's not your First Amendment right to post a risque picture of yourself on your Facebook page. It's not protected by the First Amendment, and an employee could be subject to discipline for those types of things.
Yeah, so here's a perfect example of that. Although it does have a lot of factors involved, but this is a real post. So in the scenario, it's a building inspector at the Capitol riot. Posted out there on social media. Now here, you could say, well, how can you tell who that is? There's a mask on. Okay, so that aside, let's just say that that this person was easily identifiable. This is a building inspector who goes into the public's homes, to businesses, and does inspections of whether the building code's being followed or not. And then he's putting this out there that he was at the Capitol riot. That's a tough one, I think, because all right, is there a First Amendment right to post a picture like this? You have to debate that a little bit. So is this inciting violence, or is it just I'm expressing my political view? I honestly I could see the arguments on both sides of this. I will say that a lot of employers have taken action against employees who are posting things of them either at this particular riot or other demonstrations like this that suggested violence or might have supported violence, and where the employers could show that it actually was kind of advocating violence, similar to what the other picture we saw. Then I think that they can act on that. If it's just, and I had this exact one, it was somebody who was outside the Capitol, not like this, not in the midst of the riot, just outside the Capitol on that day, took a picture and said, I'm here to support President Trump. And that, we actually had an internal debate here about that one. What do you do with that? It's not in the midst of like breaking down a door or starting a fire or hitting somebody with an American flag or something like that. It's just, I'm there. Is that enough? And honestly, I'll tell you my own conclusion on that, which is I don't think that's enough. That's expressing a political view. Is it disruptive? Well, yes, but how disruptive? Who saw it? And in what way was it disruptive? Is that just the similar to somebody having a bumper sticker and nothing else? I think obviously you could argue the other side of it is say just mere presence there suggests something, but posts like this I think are in that gray area where it's going to depend a lot on other employees' reactions and what the context is and what happened thereafter if there were discussions about it. Or for example, looking below, you can't really read it, but what are the comments from the person who posted it and what were the reactions there too? This is a challenging one for sure.
Mm-hmm.
I see there's a question. Before we get to the question, I wanted to say something on that too, Gabe. And I think the example you were alluding to, I think I was involved in that one as well, with the picture of somebody that was there. And then again, the person was a teacher, I believe, if we're talking about the same one, in an urban district. And the teacher has, as her Facebook friends, a lot of parents, and which is, there are pros and cons in doing that. But the parents see this. And again, it's just, she's posing for a picture, like a selfie, the Capitol's in the background. She's not storming the gates or anything like that, but she's there. And the parents see it, and the parents contact the principal, they contact the superintendent and, raise concerns. How can we have this person teaching our kids when she's there, participating in this riot? And so, could an employer say, look, this post has created a disruption, has resulted in a disruption to the learning environment. These parents don't want their children in your class, et cetera, et cetera. It's undermined your ability to establish a rapport with the students. Perhaps you're insensitive to their plight, those types of things. And we were able to get an amicable resolution to that one, but because it wasn't so definitive like the post you see here. And that one, to my point, I keep raising, and I apologize for doing it, but on that teacher, the union got right behind her, and said, we're not going to let her resign. We're not going to let her be, disciplined or unnecessarily. And I think, her colleagues came to her defense on both sides of the political spectrum, and that was nice to see. She was a good teacher. So again, avoid at all costs, I would, for employers on this call, selective enforcement, and unions obviously as well.
It was actually, I know about that one, Eric. I had a different one with a custodian, same thing though. It was on the steps of the Capitol, posting something. But Gail, did you say we had a question?
Yeah, we do. And this goes back to the mask question and, whether a government employer could prohibit political masks without having to prohibit, for example, sports teams masks. So now you're making a distinction based on content.
Well, I think Eric and I are both saying it should be content neutral, period. So no slogans, political or otherwise. I think that's the safe way to go. Could you split it up and say, well, no political statements, but you can wear this? I think that is a defensible position, but why get into that debate? I would just make content neutral. You can't have anything on there. It's no slogans on masks. And a lot of employers have that in their dress code. Like, for example, on business casual, no shirts with slogans of any kind on them. We want a neat appearance, and you shouldn't have anything on there. And I think that's probably the most advisable way to go. All right. Our last topic is defamation and disparagement. Eric, I'll grab this one.
Sure.
So we're familiar with defamation and disparagement and what that all means. Defamation is obviously not protected if it's a false statement or somebody makes a statement with reckless disregard for the truth. Disparagement is the tougher one. So I'm making critical or unfavorable comments. And that depends on a lot of different factors, context, subject matter, words used, et cetera. Similar to what we're talking about on the First Amendment is that you have to look at those different things, because somebody can be disparaging someone in such a way that it's going to influence the work environment. And then it's not going to be protected if it's too disruptive. But I think the key there is, and I've seen some employers fall into this trap, is just because an employee is critical of a supervisor or critical of their organization doesn't mean that it's not protected. You still have to look at the same analysis. Is it a matter of public interest? Is it too disruptive? Are you speaking as an employee or not? So, I've heard some employers say, well, it's disloyal to us. Like, well, wait, hold on. Let's see. What was the person saying? If they're saying you have a product that's dangerous to the public, and you're saying that's disloyal, so we can do whatever we want with you, that's probably not going to fly. You have to tap the brakes and go through the whole analysis.
Okay, a couple more scenarios, and we'll open up to some more questions, hopefully. Here, a public affairs officer posts on Twitter that members of the Board of Finance are corrupt, and specifically points out business interests that the members have with the town. And then the same employee identifies himself as a town employee and uses the town logos on his Twitter page. Is this going to be protected speech? Well, if you stopped after the first bullet point, it may have been. Right? If he's speaking about a matter of public concern, you have elected officials that are potentially have conflicts of interest with other members of the town or the finance committee, speaking about a matter of public concern, most likely would be protected. However, he obviously identifies himself, which is fine, but he's now using the town logo on his Twitter page. That may not be protected. He may find him or herself subject to discipline. It's never a good idea to, when you're making speech, to identify yourself as a representative of your employer. Then it's arguably not your speech. It's speech of the employer, which you're not authorized to make. So under this circumstance, I would suspect this employee would find himself in deep water.
Yeah, and I agree. That's the key factor, is that identifying as a town employee and using town logos that, yeah, it suggests that the employee is speaking on behalf of the town, which obviously is maybe unauthorized to do. Let's do the last one, and then Gail, if we have any questions, we can wrap it up. But so the last thing is nurse is concerned about conditions at a private nursing home. So the nurse posts pictures of the nursing home rooms, trying to show the conditions, and includes images of the residents. Also reports the number of COVID positive residents and blames the management. Never says where she works. So we don't have the problem that we had in the last slide. So again, this is sort of as you go down the bullet points. Speaking about conditions at a private nursing home, I think that's, even though it's a private nursing home, it's in the public interest of what's going on in nursing homes, particularly during the pandemic. So I think that gets into the realm of protected speech, but then it goes horribly wrong after that. It implicates a whole lot of issues. Posting images of the rooms and the residents, it's a HIPAA violation, most likely. Posting the reports of the number of COVID positive residents also could be a HIPAA issue, could be a confidentiality issue. That type of stuff is going to take it out of the realm of protection and take it into a whole different world. And so this is a good example of where we say good intentions are bad conduct. The good intention here was, I'm trying to protect nursing home residents. That's good. We want that to happen, and that's valuable speech. But then it turns into something else in the way that it is communicated. And I think that is important for both sides of the table to look at that and say, okay, we understand the heart was in the right place here, but we have to look at the way that it was done. And so the context and the manner is very important, and turn this into something that otherwise I think would have been protected activity. So that was our last slide. Gail, how are we? Any more questions?
I don't see any questions right now, but one of the things that I would just like to share, which is more on the private side, and which we learned from experience the hard way, is that if you as an employer have one of these claims, really, engage your outside counsel quickly, because this is not the kind of claim that's going to get addressed on summary judgment. These are going to be, difficult factual issues. I mean, just by virtue of the discussion that we've had here today, nothing is that clearly, stated here in terms of what's good speech, what's punishable speech, what's et cetera. And, you have to handle these things very carefully, because before you know it, you could be dealing with a jury trial situation.
Yeah, I think also on that, in the spirit of our organization here, both sides have an interest in doing damage control if there's some speech involved that is going to be an issue for the employer or the union. Mm-hmm. And I think that the parties should be encouraged to talk it through. The example that Eric gave, where the parties got together and sort of dealt with it, that's good, because really, it doesn't, if somebody's posting something about that, the person driving through the crowd, the employer doesn't want to be associated with an employee like that, but the union doesn't necessarily either, even though they're going to defend them. And so if there's a way that the parties can get together and sort of figure out how do we deal with this issue and maybe neutralize it, I think that's in everybody's best interest.
I agree wholeheartedly. And what you can wind up have happening is, let's take the teacher who took selfies in front of the Capitol on January 6th. Again, not storming the Capitol, just she was there. And the employer was looking to initially the employer was looking to be heavy-handed with her. And as you can imagine, as all of us can imagine, this teacher and any other person similarly situated has a lot of people in her ear saying, you're being discriminated against because of your political beliefs. You have to fight this, and perhaps rightfully so. But what you're going to wind up happening is, if an employer isn't willing to resolve this amicably, and you are heavy-handed with someone like this unnecessarily, I'm speaking as a union advocate, of course, what you're going to have happen is you're going to have another riot outside of the arbitration doors. You're going to have people that are supportive of that political view come to her defense, and demanding that, she be treated the same as anyone else who may have posted a selfie of themselves during a Black Lives Matter protest and wasn't disciplined. Right. So to the extent that you can resolve these amicably, I think it is in everybody's interest. And of course, you want it resolved in a way that, is rehabilitative. The employee becomes a better employee as a result of it, not terminated for it unnecessarily.
So one other question, I know a few times both of you referenced the need for employers to have content neutral policies. So I don't know if you have a couple of examples of some terms that employers might want to consider putting in those policies.
Well, I know that I'll just give one that I can paraphrase that was in the healthcare environment. That it basically is what I alluded to before, which was employees shall not wear any buttons, shall not wear any hats with logos. They shall only wear their name tag on their uniform and nothing else. And that's it. It was really kind of that simple. And that covers a whole host of things. But the proof's in the pudding, really, which is you have to enforce it in that way too. You don't let somebody wear the Red Sox pin and let it go. Yeah, if somebody who violates that policy, you got to say no. And that's sort of it's in its purest form is nothing on your uniform, no buttons or no slogans or whatever. And it can be that simple.
And we're not seeing it so much now, but we were certainly seeing it when more and more schools were closed and were virtual. Is we had teachers would have political logos in the background, whether it was their virtual background or whether or not they just had a sign in the back. And some parents may disagree with the political speech, the sign, and I've seen employers when the schools were virtual, when more schools were virtual, come out with policy saying no political slogans in the background when you're teaching the students, because it presents a problem. Now is the policy going to say you can't have a Red Sox logo behind you? Perhaps not, and that might be a way where an employer would be hard pressed to come up with a policy controlling what's in the background because everyone's at home and everyone's background is going to be different. But I think it would be probably advisable and to have a policy when you're teaching virtually to students that you not have political slogans in the background.
Don't have a policy that says no diplomas on the wall because Eric and I would be sunk.
We'd all be in trouble, right?
Right.
Well, we're at the top of the hour, a few minutes past. This was great. Thank both of you. I know you put a lot of time and effort into this. And thank you all for coming to our presentation. Please check the LERA website probably within a week or two, and we'll put up the registration for the June 4th program on COVID vaccine programs. And thank you all for coming and enjoy the rest of your day. Thank you so much.
Thank you all.
Bye.